Thank you, Leigh and Lauren. Lauren, I love hearing you speak. There's a little more to my biography, which I'll disclose, which is that I was a criminal defense attorney for about 9 years, and I left to find out what else there is in the world, and I found myself at the Community Conferencing Center some years later, working as a facilitator and also doing outreach to the juvenile court system, including the police, the school police, the juvenile prosecutors, the defense attorneys in the juvenile unit, and the juvenile bench, and facilitating community conferences. So I worked for Lauren for 3 years. And it was a really interesting transition for me to go from being a defense attorney and zealously guarding the rights of my clients to being a neutral facilitator and to hear from everyone in the room. And in community conferencing, there's prep that goes into it. So beforehand, I would have talked to the anyone involved, the person who committed the harm, the people or person who was harmed, and their supporters. Everyone is prepared for what the conference is going to be like and invited, and we make sure that it's a voluntary participation and that they're there because they want to be there. So I echo everything that Lauren has said about how wonderful it goes, usually. It goes very well. And it's a good corrective to what we see in the court system, where criminal cases, as in every other sphere, the process of litigation separates people and makes matters worse for most of the ordinary people who go through the process. So having said that, I was invited here today, and I think now a lot about what we can do to glean these benefits from that I experienced firsthand and that I believe in from restorative justice, but do it in such a way that it could be more broadly applicable without risking other harms. And I think the crux of the problem is really this issue that it's impossible to get away from the criminal justice system. Because as long as we're in any state or in the US or in any place, there are criminal laws which are enforced by the state. So we can't really escape state jurisdiction. So we can say, I'm going to resolve this case out of court, and we may be able to resolve it out of court. And it may be resolved to the victim's satisfaction. And everyone may be very happy with it. But of course, if the elements of the crime could be proven, the state can always come in and prosecute it as a crime. And so this creates a unique vulnerability for the person who, in a community conference, is willing to acknowledge having committed a harm that meets the elements of a crime. And so I'd like to talk a little bit today about what that looks like and what could be done about that to make that better. Before I get to that, I just want to point out a few other contours feeding into, I think, the conference as a whole today. I see the trend in restorative justice to really mirror the innovations in family courts. There's a movement away from legal norms towards therapeutic norms or more humanistic norms. There's a move away from legal professionals to other professionals, people who have expertise in other areas, or lay people, and a movement towards self-direction and towards autonomy for the people who need to avail themselves of some sort of dispute resolution service. And all of that is true in restorative justice. Community conferencing does very well the job of framing everything neutrally so that when people have had a conflict and someone's been harmed and they're approached and invited in, there isn't a predetermination of what happened and what should be done about it. However, in the restorative justice literature, we find that it really does, in some ways, mirror criminal law. Offenders or defendants, victims on the other side, someone has harmed someone else. So there's a person who's committed the harm and a person who's done the harm. And there's a set prescribed outcome. There needs to be an accountability on the part of the offender, and there needs to be some sort of amends made or healing for the victim. And this formula may work in some instances, but I would like to suggest that in intimate partner violence, as well as in other cases, life is complicated. It's complicated, and not every case is going to fit into that. You may have situations where there have been violent incidents that go both ways. You may have situations where it doesn't go both ways, but and it really is a domestic violence situation, but the perpetrator of it may be completely unwilling to acknowledge having had any role in it, which, as Leigh mentioned, maybe that's not suitable for restorative justice, but maybe there's also a way to think about a more flexible framework. And I think that happens in practice at places like community conferencing, but in the literature, Howard Zare, Braithwaite, others, you hear this language which is very rigid, and it compromises party autonomy to a certain extent by predetermining what the issues are going to be. So insofar as we can take that and put it to the side and see what real people need in the restorative justice context to resolve intimate partner violence or domestic violence, I think it'll be more successful, both practically and in terms of its theoretical underpinnings as well. So, okay, so if it's always lurking in the background, the possibility of criminal prosecution, what do we do about encouraging candor, encourage that people take responsibility for their actions, whether they meet the elements of a crime or not? What can we do to make that safe? This is something that's been addressed, or an analog to it has been addressed in the mediation context, in terms of looking at privilege, confidentiality, and privilege in mediation. And within that context, we have a very mixed playing field. But before I get to that, the first question is restorative justice mediation? Will it be covered by the statutes that protect mediation communications in different jurisdictions to different degrees? And the answer is, it depends, and we're not sure. And so that, I think, is a real inhibitor of the growth of restorative justice. Because let's say community conferencing. So community conferencing facilitators are trained in community conferencing. You're a facilitator. It's different than mediation training. The process is different than, mediation there's many different forms, but it's another process. You could put it under a broad umbrella of mediation, but you might also decide that you don't want to characterize it that way. So if you look at the statute in Maryland, for example, on what a definition of a mediator is in the Confidentiality Act, you'll see that it doesn't really, it includes people who've gone through the 40-hour mediation training and certain requirements, and so you say, well, this doesn't include community conferencing facilitators. So there are sentencing circles, there are peace circles, there are restorative justice dialogues. Excuse me, I hope I don't cough. I'm getting over a cold here. And there's community conferencing, and none of it will be covered under those confidentiality terms. Okay, but what do those terms look like? Let's say you have victim-offender mediation, and you can say, yes, okay, so this is mediation, and so it's covered. What does it look like? Well, states like Maryland offer some more protection by saying there's a privilege. You can't be called to testify regarding what has occurred, the communications within victim offender mediation, unless there's a permissive right to disclose a threat of bodily harm that's serious or imminent, and there's abuse, child abuse, or elder abuse, right? But then if you get to the Uniform Mediation Act, there's actually a provision which explicitly allows for the admission of communications in the prosecutions of felonies, and potentially in misdemeanors as well. So you actually have a process through which, at least in the civil context, the architects of the UMA said, well, I don't know. I mean, what if we hear something in a mediation that meets the elements of a crime? We should be able to offer that to the prosecutor, or the prosecutor should be able to subpoena the mediator or a participant to testify to that, because it might be important in the prosecution of a felony. Now, it provides a procedure. It's an in-camera review by a judge who weighs the need for the evidence against the interests and confidentiality of the mediation, but it could be disclosed. And in DC, for example, DC has adopted that provision, I think, wholesale from the UMA. So if you're in DC and you have a victim offender mediation, maybe it's for a misdemeanor case. The UMA does contemplate that you might want that in a misdemeanor case, but interestingly not in a felony case. Well, in that case, then, if there's an admission made to a crime which could amount to a felony, that is not protected, or the protection could be breached if a judge deems that the evidence is needed and that that need is more important. So I think that this poses a real problem for restorative justice in terms of promoting candor, openness, and allowing for the kind of healing that's possible. And I also think that it prevents it from scaling up. I think there would be a legislative fix, but I think that it does get right to that heart of the issue of what do we really believe should happen with crime. And this fear that, offenders in serious crimes will simply get to talk about what they did and get forgiven by their victims, even though the state has an interest in in prosecuting or in retribution or some form of punishment like that. So I guess I would propose, as we move forward and think about it, that there is still a role in restorative justice, as I think there is in family mediation in general, for attorneys and for legal norms. Because as the playing field is right now, it would be very difficult to imagine an attorney allowing a client to participate in a full discussion of what had happened during the course of a relationship in a room full of many people, all the supporters and friends of families of the person who had been harmed, his family members, other people who might be interested, to talk about what happened and try to resolve it, knowing that there was no protection, and knowing that even though everyone in that room may have resolved the conflict, that they could all be subpoenaed and come into criminal court at a later date and testify. So it puts a limitation on it, and it also suggests that there's a role for attorneys in the process and in also changing and shaping what the rules are around it to allow it to be used more often. My voice is going out today, so I would love to talk more, but I think I better leave it at that, and we can leave it open to questions as well. And yeah.